and welcome to the arbitration conversation. So in this episode, we're going to talk to true entrepreneurs, leaders in the space of online dispute resolution, and specifically OARB, online arbitration. And today what we have is the founders, really, Richard Ormond and Jake Stango. So I have two for the price of one, so this is pretty awesome. So first of all, thanks guys for taking time with me.
Thank you.
Our pleasure. Thank you for having us.
So I guess I first want to hear, what is ejudicate?
Jake, go ahead.
Yeah, ejudicate is an online arbitration platform that's akin to JAMS and AAA. And really the difference is rather than it being in a traditional brick and mortar fashion, we do everything cloud-based and it's done entirely asynchronously.
Oh, cool. So is it all text-based or do you use video at all?
Great question. So we start off as a document-only arbitration process. Once the e-judge is assigned, he or she then clears conflicts, has the opportunity to review the information provided by the participants, and at the discretion of the e-judge, he or she can then opt to do a live hearing, which can be telephonic or video.
And I would assume the sort of added benefit of a platform like yours is it provides the security which you would not have if you were simply exchanging emails, for example.
Absolutely, and I think it's a little bit more than that. It's also efficiencies of both time and cost, which is, traditionally, sometimes the cost to arbitrate can actually be more than the amount in dispute. And so these efficiencies create for greater economies of scale, providing access to justice for everybody.
Well, so I guess I want to go a little bit further on that question because, sort of your journey and how the two of you decided, hey, let's have a startup and let's go ahead and kind of create this whole process using online arbitration. What was your thinking and what was sort of your inspiration?
So I've been a litigator for 22 years and I have had those Pyrrhic victories where you win the case, but you don't feel like you've won anything because you've spent the same amount of money to get to the point where you're actually victorious, to get a judgment where if you're owed $200,000 but you've spent $200,000, it really seems inefficient. And after years of frustration of dealing with those inefficiencies, I teamed up with Jake and our other partner, Jeremy, to try to figure out a way to use available technology to develop a system that was much more efficient, that we could do at a flat rate, that we could do within a certain amount of time. And what's interesting is we actually developed our own technology that is now patent pending because there was nothing out there that allowed for multiple parties to interact in one interface the way that our platform works. So we now have a patent pending for the ideas that we came up with back then in those initial days. For us, it grew out of the idea that providing access to justice to all types of people, whether they have money or don't have money, was important. There's a barrier to entry to law, whether it's hiring a lawyer or paying for an arbitrator and getting your day in court. And there are certain types of cases that don't require the intensity that a full-blown litigation requires. So we have put discovery, rather than have the parties conduct discovery against each other, we have the judge, after reviewing the evidence, ask the questions of the parties to fill in any gaps of information, which we took from civil code countries, because that's more of a civil code country kind of procedure. We looked at different processes around the world to figure out what would work best for these types of claims. We know that if you have a case that's $500,000 or more that has claims other than contractual claims or declaratory relief claims, we might not be the best platform for you. But if you have a contract where you're owed money, for example, like a promissory note, if you're owed money on a promissory note, most of the evidence is going to be in the documentation. What constitutes a default? Did the default occur? Was a default notice sent out? And there are boxes, in essence, that a judge can check to make sure that all of those requirements have been met. Look at the evidence, look at the testimony, and come to a pretty fair conclusion as to what the parties are entitled to in that dispute. And we wanted to create a forum that took advantage of all of those efficiencies. That is my house phone.
Well, and I would think that with COVID-19 and with the pandemic, your timing is kind of perfect to be providing online justice. How's it been going for you since the pandemic hit?
It's been going well. Jake is our operations manager, so I think he can probably better address.
Yeah, I mean, I think that, no one ever envisioned that the pandemic was happen. No one ever, wants this to be here. I think that the serendipity of us building kind of a counter-cyclical business before the pandemic is fantastic. For us, we're really, focused on continuing to validate product market fit. Moreover, providing, expediency and kind of quick results to the people that are looking to get these cases arbitrated.
So along those lines, with promoting and expanding access to justice by creating an online mechanism for these smaller dollar claims, I guess I was also wondering, did you engage in any sort of user testing or think about user-centric design in order to help it be more user-friendly, to help with access to justice?
Yeah, absolutely. And I think for any web-based platform, UI and simplicity, and I think you know is of critical importance. And so as we were building the product, getting real-time user testing, conducting user interviews was very, very important, and something that frankly we still conduct daily. We're monitoring things, we're talking to users, and we're doing this. My previous experience before partnering with Richard was helping another lawyer develop an online platform that helps individuals get an uncontested divorce. And the platform was ultimately akin to TurboTax, but rather for taxes, it was for divorce. And very similarly, the product was geared towards a B2C audience. In that instance, conducting user interviews was, again, of utmost importance. Ejudicate's target is a little bit different, but again, UI is incredibly important. Our customer base is really businesses to business, so B2B. And we're, again, kind of focused our initial launch into monetary claims. So even though businesses are using the product, these are men and women within these organizations that are using it at terminal on their end. And so UI is critical.
Yep. And when we initially started talking about it, we wanted it to be easy to use for someone that had a law degree or that was that didn't have an advanced degree, that someone that could understand the questions, understand what's being asked. To that end, one of the interesting things that we went through was we created a glossary that is accessible on the website, because there were terms that we chose that we thought should be defined so that people understand exactly who's who and what's what and everything through the process. So we've tried to make it very easy to use in that regard, and you can hyperlink to that definition if you're unsure. But using a term like respondent versus defendant, for some people that's legalese, and we wanted to avoid choosing words that only lawyers would understand or that would have some sort of implication to a lawyer versus to somebody else. And so we were very cognizant of that. And we had very good outside advisors that would run through the system and try to break it pretty much. And we would then interview them, download their perspectives, and then revisit the website to make sure that it was conforming to their needs.
That's a good idea. I mean, so often consumers, especially, and small business owners as well, when you have this legalese, it's kind of hard to even know what you're required to do on a platform like this. I guess the other question I have for you is, who are your judges? Who are the arbitrators?
So we have done this. I jokingly say it's like Uber for lawyers. We have a standard that we put out there, and it's a little bit flexible, but in essence, we want to get people that have 10 years of expertise in a particular field, that they have no professional discipline against them, and that have obviously the availability to handle these cases. It's a little bit like Uber for lawyers in essence, so that if you are a lawyer that, for example, works from home, or if you're a part-time lawyer and you have some free time because the kids are at school or because a case is just finished up or whatever, you can log in, see what cases you qualify to be a judge for. And if you're the first to clear conflicts and claim that case becomes your case. So we do it off of this wheel that we've created. And that's part of our patented technology is how we get those cases to the judges. One of the things that we found was that by us assigning the judges versus the parties trying to pick a particular judge, it became much more efficient for everyone. And in these claims that are really monetary claims or declaratory relief claims, what's most important is the judge's background and experience versus their personality traits, because the hearings are nominal, the and it's really based more on the evidence that's presented than anything else. So we're less worried about there being some sort of inherent bias in the judge, because in many instances, you may not ever actually see that judge. You may hear them on a phone call, you may see them on a Zoom, but chances are that the judge will be reaching out to you through some sort of electronic communication.
Wow, yeah, no, that makes sense, and especially in these kinds of claims.
Mm-hmm.
I guess, talking about barriers to entry as well, you mentioned it's a flat rate. So how does it work for a company that is interested in signing up? Is it a subscription, or is it a flat rate for each arbitration?
Mm-hmm.
Most of our product is priced towards a SaaS, which is a software as a service enterprise software. And so again, our target audiences are businesses that have multiple defaults that they're trying to find more efficiencies to resolve. Most of our clients are signed up on a subscription model that's credit-based. Contingent upon the claim journey, the claim will pick up costs. So at the beginning of the claim, we don't know if the defendant is going to participate or if they're going to not participate. So again, it's very, very straightforward pricing. The claims pick up credits along the way, and contingent upon its journey, that's how the pricing works. We do offer one-offs. Sorry to interrupt you, Richard, but we do offer one-offs, but the majority of our clients, again, are using a subscription.
That's right. I was going to mention we have a one-off program as well, and that's based really on the amount in controversy. So we have kind of a sliding scale of costs in that regard.
Yeah. Well, this is all really exciting, and congratulations on getting this off the ground. It sounds really exciting. I've seen the website, it looks really good. And thank you for taking time with me today. This is really good to learn about online arbitration with ejudicate. Thanks, guys.
Thank you.
Thanks,
Appreciate the opportunity.